reference for the Attorney General for Northern Ireland devolution issues under paragraph 34 of Schedule 10 to the Northern Ireland Act 199.
If I may say so, without, I hope, sounding in the least patronising, it's a real pleasure to see a row of female counsel in front of us. It's a very I can't think of any occasion previously when I've sat in this court that that's happened. It's a nice change. Lord Advocate.
Yesterday I began my submission by seeking to emphasise the need for safeguards if this court were to answer the question posed in the reference in the affirmative, that individuals with impaired decision-making may be understood to be consenting to confinement through expression of wishes and feelings. I suggested that safeguards are necessary, and if they are not adequate, the confinement that follows will be arbitrary and unlawful. And so this morning I make this point at the outset of my submission. It's not that the Minister of Health's proposal is unlawful. The point I was making was that which is set out at paragraph 24 of the written case, which is at page 84 of the hearing bundle, under the reference M against Ukraine. The court ultimately, in that case, at paragraphs 82 and 90, concluded that the applicant's admission and stay in hospital were not supported by adequate procedural safeguards against arbitrary deprivation of liberty in violation of Article 5.1.
Is this an Article 5.1 point or an Article 5.4 point?
So, as I understand it, the court was looking at a number of issues arising under Article 5, and the question was one as to whether or not to give valid consent, that necessary for limb B of that necessary to bring the position of the patient into one of confinement as opposed to one of deprivation of liberty. So the question for the court in M against Ukraine related specifically to the nature of the consent given by the woman in that particular case, and there was a question mark over the processes because she had actually signed a form, but there was a question over the procedure involved in that and the supporting evidence that demonstrated that it was indeed valid consent. So to clarify that particular statement, the conclusion of the court in M at paragraph 90, which is in the hearing bundle at page 4836.
Sorry,
4836.
Thank you.
Was partly based on the fact the applicant's admission to hospital and retention there were not supported by adequate procedural safeguards against arbitrary deprivation of liberty. The court in M doesn't actually spell out the point, but it is clear from other cases, such as HL against the UK, at paragraph 119, which is in the hearing bundle at page 4634, that avoiding arbitrariness is an element of lawfulness. So if one looks at paragraph 119 of HL, there the court says whether or not the above allows the conclusion that the applicant could, with appropriate advice, have reasonably foreseen his detention on the basis of the necessity. The court considers that the further element of lawfulness, the aim of avoiding arbitrariness, has not been satisfied. So what I was taking from M against Ukraine on that basis is that a lack of or inadequate safeguards might rise to a complaint in respect of either of the accordance with law requirement under Article 5.1 or the lawful detention requirement of Article 5.1e. put the point no higher than that. I'm not arguing that there is necessarily unlawfulness here. It is a matter for this court if it accepts that valid consent can be given by individuals with impaired decision-making as to what is required by way of adequate safeguards, and whether indeed the safeguards proposed by the Attorney General of Northern Ireland in her written case meet that necessary standard. A number of concerns have been expressed by the charities and the official solicitor about the difficulties in obtaining true consent from some individuals. Some of the case studies that we see that have been produced by the charities and the statement from the official solicitor herself are indeed very moving and profoundly troubling. But I do not intend to make submissions on those concerns which the charities and the official solicitor can plainly articulate for themselves. But I would invite the court to have regard to them in considering what might be necessary by way of safeguards and the adequacy of what is proposed.
But I mean, surely before you get into safeguards, you have to have a clear understanding of what the concept of deprivation means.
Yes, that's right.
I mean, speaking for myself, I thought that that was the primary focus of the reference, because the statutory code of practice isn't purporting to lay down absolutely everything that will happen in relation to someone who may be taken into a care home or something like that. Clearly there will be a whole raft of procedures involving social workers and so on. So some of I'm sure you're right that there is statements in the case law that says avoidance of arbitrariness is a feature of Article 5. That's quite a well-known feature of the jurisprudence, but that just doesn't seem to be the real focus of what we're concerned with.
Well, I acknowledge that this is part of the analysis, though, that is important for this particular case of concern relating to safeguards. But I appreciate fully the issue before the court is Article 5, deprivation of liberty, and the criteria to be applied. But I do acknowledge the argument that the charities and the official solicitor make that having regard to the terms of the statutory provisions governing capacity in England and Wales and Northern Ireland, there may in fact be a limited number of situations in which a person who lacks capacity in relation to a particular decision can nonetheless validly consent to confinement. But it is a matter for others as to whether such clarification of the scope of deprivation of liberty as might be achieved in this reference will actually achieve the outcome that's sought. So for my part, as I've set out in my written case, I submit that the Strasbourg case law does support the conclusion that, at least at the level of principle, consent to confinement as an autonomous concept can be given, notwithstanding a lack of capacity in law. And that is reflected in how the written case was drafted. And we can see that at hearing bundle page 81 and at paragraph 16, I set down the authorities that I rely on for that proposition. And these were all authorities that were looked at by Mr. McLennan yesterday, and they're summarised at page 81 at paragraph 16. I'll just show the court that particular paragraph where all the cases that Mr. McLennan referred to yesterday are listed. These authorities were also discussed in Cheshire West at paragraph 31. And I think it's helpful to look at Cheshire West, which at paragraph 31, which is at hearing bundle page 2946. At page 31. So there, Baroness Hale sets down the cases that Mr. McLennan was referring to yesterday and explains that in all these cases, the applicant lacked the legal capacity to consent to the placement. To tower off, the court decided that the applicant had been placed in a psychiatric hospital at the request of his legal guardian, which in Russian law was regarded as a voluntary admission. Although he lacked the de jure legal capacity to decide for himself, this did not necessarily mean that he was de facto unable to understand his situation. Indeed, he had evinced his objections. The subjective element of lack of consent was made out. The court took the same view in DD and in Ketsu. Thus, it appeared to give some weight to the objections of a person who lacked legal capacity when deciding that the subjective element was made out, despite the consent of the person's legal guardian. But in Milov's, the court seems to have gone further. In relation to one of the care home placements, the court held that there was a deprivation of liberty because, although the applicant lacked legal capacity, he subjectively perceived his compulsory admission there as such a deprivation. In relation to a later placement, however, he did not raise any objections or attempt to leave, and the court concluded that he had tacitly agreed to stay there, and thus he'd not been deprived of his liberty. In contrast, of course, in HL, the patient was deprived of his liberty in the hospital despite his apparent compliance. So I accept that the cases which support that conclusion concerned individuals who'd generally been divested of capacity, whereas the domestic framework for assessing capacity in respect of particular decisions operates differently. So the domestic framework assesses capacity by considering, in particular, decisions that require to be made. So yesterday,
So is this your point, that given what appears from the cases to be a great diversity amongst the contracting states as to how they go about deciding whether someone has mental capacity and what that test involves, perhaps it's unlikely that the Strasbourg court is tying the element of consent in Article 5 to that domestic test, whatever it may be. So it is an autonomous concept. But is your point that given the nature of the test in this jurisdiction, it's going to be quite rare that someone both doesn't have mental capacity but also can validly consent?
That's right, and I think that's the point that the charities are making, and the official solicitor, who have far more experience of the way in which the system operates here, and that's why it's very much, I'm leaving that particular analysis in the sense of further exploration to those who have specifically raised the point by reference to the statutory framework under the 2005 legislation.
But I mean, that submission is going to depend critically on what the autonomous concept actually involves.
It is.
So if the autonomous concept of ability, to avoid using the word capacity, ability to give consent is quite a low level of subjective understand, that someone subjectively understands their position, the environment in which they're in, but at quite a low level, well below what we would regard as capacity to understand in terms of legal capacity to understand, then the congruence between our domestic concept and the autonomous concept breaks apart, doesn't it?
I agree with that.
I'm so sorry. Can you keep your voice up? I'm struggling to hear when you're facing that
The
way.
microphones are not placed very well.
I don't think
The microphone doesn't broadcast your voice. The microphone records what you're saying, so you have to keep your voice up.
Thank you. Thank you.
If you think about it, in England and Wales, anyone under the age of 18 doesn't have legal capacity. But a 17-year-old obviously can express meaningful views about treatment in a residential,
Of course.
a hospital or a care home.
Yes. So,
And indeed, the fact that the 17-year-old would have legal capacity in Scotland rather illustrates the diversity
yeah.
of approaches in domestic law, which clearly can't be determinative at the convention level.
Yes, that's right.
Do you accept the autonomous concept of consent being an ability to understand, to comprehend? Is that the basis of it?
Yes, I do.
And as articulated by my Lord Sales, do you accept that approach?
Yes, I do.
Yeah.
So yesterday I also explained that the issue of valid consent was not looked at by this court in Cheshire West, and the position of all three parties in both cases, at least from the Court of Appeal onwards, was that there was no capacity and no valid consent. And in that regard, I'd refer the court to the case of Mig and Meg that was in the Court of Appeal, and the reference there, Hearing Bundle 2850. There, at paragraph 9, at the appeal level, it was recorded in the decision of the court that the impairment in the functioning of their minds renders both P and Q unable to make decisions for themselves in relation to anything other than the most trivial day-to-day aspects of their lives. So they lack capacity in relation to all matters relevant to these proceedings for the purposes of Section 2 of the Mental Capacity Act 2005, notwithstanding the potential improvement in level of Q's functioning. The incapacity of both of them is almost entirely permanent.
Is that addressing the domestic concept of capacity?
It specifically refers to Section 2 of the Mental Capacity Act 2005.
And did the Court of Appeal address wishes and feelings? Because those were dealt with by the first instance judge at paragraph 234, who found that their wishes and feelings were manifest and clearly expressed.
I think it's difficult to see what happened between the the first instance proceedings and that in the Court of Appeal, because ultimately what was said in the Court of Appeal and the position before the court in Cheshire West was that there was no valid consent. Now,
But again, are you accepting that in paragraph 9, what the Court of Appeal, what Lord Justice Wilson is talking about is the domestic test?
I am, yes.
It was a finding, in fact. If we don't have it in our bundles, but I've got in front of me Mrs. Justice Parker's judgment at first instance, and she says in paragraph 234, referring to Mig and Meg, their wishes and feelings are manifest and clearly expressed. They plainly have no subjective sense of confinement. In a non-legal sense, they have the capacity to consent to their placements.
Yes, it does say that. I've seen that.
Yeah. Perhaps I could just say that's quoted by Lord Clark in Cheshire West, page 2967, if you want to follow it. So, 2967. So they were in a situation where they were capable of understanding admittedly in a fairly minimal way, whether they were being confined or not.
That's right.
And with that level of understanding, were expressive of being content with the situation that they were in.
That's right.
So why doesn't that, if the autonomous concept of valid consent operates at this relatively minimal level, why wouldn't that count as valid consent?
Well, I think that what I would say is I'm not sure about the extent, what was supporting that, or the extent to which it actually related to the nature of the confinement. I'm not sure if the analysis of the judge at first instance really is of sufficient detail for me to answer that. But on the principle, I don't disagree at all that an individual who's capable of evincing wishes and feelings and is able to indicate that they are content with the arrangement, that would be grounds to hold that there's valid consent. I don't disagree with that in principle at all.
But how do you say in Cheshire West Limb B came to be irrelevant, standing what Mrs. Justice Parker said at paragraph 234? I mean, paragraph 9 of the Court of Appeal judgment isn't sufficient because it's talking about the domestic test.
Yes, it is.
So what is there in the Court of Appeal judgment that blows away the autonomous Strasbourg concept?
So if we go to paragraph 18 of the Court of Appeal's decision at page 2852, it says neither P nor Q is in a position to give a valid consent to any arrangements for their care, so the element at 17b above exists.
Was that an agreed position between counsel?
That's what I'm saying. It's difficult to see what had happened between first instance and appeal for the local authority to adopt the position that they did. First off, that the individual was capable of giving valid consent, yet at appeal this was a joint position of parties. And this is in my written case.
So, sorry, were you saying in the Court of Appeal this was the joint position of the parties?
I understand that to be so.
But was Mrs. Justice Parker at 234, she says their wishes and feelings were manifest and clearly expressed, but was that apropos of whether there had been a deprivation of liberty, or was she dealing with what would be in their best interests at the later stage?
Well, I'd need to go back to the judgment to look at that and answer that particular question.
Well, I mean, I think it is about deprivation.
Yes,
I'm looking at page...
I don't know.
I mean, it's unfortunate we don't have the judgment before us, but we've got quite an extensive quote at page 2966.
You have the judgment, actually, in
the first instance
hearing
judgment.
bundle, yes.
Oh.
Yes. And it's at... so I've got references here. I was trying to cut through because of the time, but if we go to hearing bundle page 2713, Mrs. Justice Parker.
Yes, 209 on that page is quite helpful. She's living in an ordinary domestic environment which she regards as home, not restrained in any way, not locked in. She does not wish to leave. She wants to stay with her foster mother.
Yes.
She loves her and regards her as her mummy.
Yeah. So if we look, there's a number of references that I can highlight. 208, one that my Lord has just looked at.
Well, so, we can come back to this, but just before we drift away from my lady's question, I think that was about 234 and whether that was directed to deprivation. And I just pointed...
Look at 204, sorry. Is that what you
Well, sorry, just for the context of 234 in this judgment, I think if one looks at 233, page 2718, the focus there is deprivation, and 234 is the sort of follow-on from that. So I think that the context of 234 is discussing deprivation. But I'm sorry, my lady wanted to go back to 204.
Yes, I mean, 204, she says, this may be what was agreed, a person who lacks capacity and who cannot therefore give or withhold consent may nonetheless express a wish not to be in a particular setting.
So I can give the page references for Meg and Meg's case. Paragraph 208 at hearing bundle, page 2713. Paragraph 218 at hearing bundle 2715.
Sorry, just as we're skipping over these facts, it's clear that both Mig and Meg, if I can call them that, had a basic level of consciousness of their circumstances. They didn't have legal capacity, but they were sufficiently conscious of their environment to know whether they were happy there or not happy there.
At first, according to the findings of fact.
Yes.
by the trial judge at first instance.
Yes, all right.
And at 204, the judge says that would be relevant to the subjective element. So even though they can't, they didn't have legal capacity to consent.
It would be relevant to
The subjective element.
test,
Yeah. The autonomous Strasbourg concept.
Yes. Just to give all the references to the question of capacity, there's one more that I would like to highlight from Megan's case. It's hearing bundle page 2711. And that's a legal conclusion that a person who lacks capacity and who cannot therefore give or withhold consent may nonetheless express a wish not to be in a particular setting. And in relation to P's case, at first instance, if we go to hearing bundle at page 2818, paragraph 1 confirms he is a man who lacks capacity.
So this is in Mr. Justice Baker's judgment.
Yeah, and at paragraph 46, at hearing bundle 2829, it says, in determining whether P is being deprived of his liberty, the court must follow the following legal principles. So far as the subjective element is concerned, whilst there is no deprivation of liberty if a person gives a valid consent to their confinement, such consent can only be valid if a person has capacity to give it.
Which paragraph, please?
That was paragraph 46.
But that seems to muddle up the autonomous concept with the domestic concept of capacity, doesn't it? Following your submissions up to this point.
Yeah, so, and if we just look back to paragraph 3 on page 2818, it describes P as a 38-year-old man who has lived in Cheshire all his life. He was born with cerebral palsy and Down syndrome and has a history of cerebral vascular accidents. His presence, he presents with significant physical and learning disabilities. It is accepted by all parties that he lacks the mental capacity to make decisions as to his care and residence.
But again, aren't they talking about the domestic concept?
They are, very much so. I don't disagree with that.
Pardon?
I don't disagree at all.
You don't disagree, but doesn't it then boil down to Lord Sales's point that there seems to be a conflation of the domestic and the autonomous test?
Yes. And then whatever happened between first instance and appeal, the position of all parties were that none of the individuals were in a position to give a valid consent. And I referred back to hearing bundle page 285.
But that again, it depends on what is meant by valid consent as a matter of the Strasbourg autonomous concept. We can see that they clearly didn't have capacity in a domestic legal sense to give consent. But it appears, and I think you've accepted this, and indeed it's part of your submission, that that's not the relevant question.
Yes.
But one might say that there's an element, perhaps, of confusion has crept into the case law, even from first instance here, with people talking both about capacity in the domestic legal sense, which is not the relevant concept, but treating it as though it's that governs what counts as valid consent for the purposes of the Strasbourg concept, which would be wrong if that's what's happened.
Yes. For the very reasons that were pointed out at the beginning, because of what the Strasbourg cases say, and indeed that was explored by by Baroness Hale in Cheshire West. So I have set out clearly in the hearing bundle, in my written case, that that's the position in principle.
Right. Can you help us with this? I mean, we saw, I think it's paragraph 37 in Cheshire West, it's recorded that it's common ground that factor B from the Stork test, i.e. the subjective element, was not an issue on the appeal. Is that because people were operating on the basis of this conflation between the Strasbourg concept of valid consent and the domestic concept of capacity, and therefore we're assuming that valid consent for the purposes of application of the Stork framework was out of the window, because we were dealing with cases of people who didn't have legal capacity in a domestic sense.
So it may very well be that that's the answer to how things developed from appeal through to the Supreme Court. But the point is, ultimately, the Supreme Court didn't consider the issue of valid consent, and it would be open to this court to clarify that. Now, whether that resulted from a misunderstanding of what valid consent could be, whether it was assessed in terms of the legal framework or in terms of a subjective assessment under the Stork test, it's difficult to see where if there was an error, how it might have crept in. But that might explain why it was that the court in Cheshire West didn't look at the issue in detail, and that's why we say in our written case that the court, it is open to this court to clarify that issue as to what might be acceptable as performing the necessary test for valid consent.
Yes, thank you.
So that's, I think we make it clear that we say in our conclusions, if you look at the hearing bundle, at the very end, in our conclusions, at page 90, that in relation to issues 1 and 2, on the hypothesis that the court considers that consent may validly be given to confinement by persons with impaired decision-making by way of the expression of wishes and feelings, I submit that certain minimum procedural safeguards for the obtaining of consent are required in order for the proposed action to be lawful under the Convention. Certain safeguards have already been proposed by the Attorney-General, and if they are considered sufficient insofar as it requires them to consider them at all, I respectfully suggest that it's open to the court to answer the question posed in the affirmative. In relation to the second issue, my position is that the decision in Cheshire...
You mean in the negative. The question referred asks whether the guidance would be invalid as incompatible. But I think you're saying...
Yes.
No, it would not be invalid.
Yes. And so, in relation to the point that we're discussing at the moment, though, we go on to say that the decision in Cheshire West didn't set down a general rule on the basis on which the reference proceeds, that legal incapacity necessarily means a factual inability to consent. It accordingly doesn't require to be departed from on the basis suggested. So we say, you don't need to overrule a Cheshire West on that basis. You simply clarify the position in relation to what...
Yes, but you are right that your submission asks the question in electronic bundle 4, paragraph 1 of the statement of facts and issues in the affirmative, because the question is whether he has power. Yes, so you're correct to refer to the affirmative.
Yes. So I'll now address the Secretary of State's invitation to the court to depart from the decision in Cheshire West insofar as it sets down an acid test for the objective limb. It's important to emphasise at the outset that I agree with the Secretary of State and the Attorney-General that it is in principle appropriate that wishes and feelings of a person with impaired decision-making are taken into account. My position, as set out in my case, is that it's open to the court to adopt the Attorney-General's proposed approach via Limb B. The only issue between us is therefore as at the stage or Limb B in which they are taken into account. So the only issue is the stage at which the wishes and feelings are taken into account. My submissions on Limb A and Cheshire West are directed towards ensuring which limb is correct. So before turning to the arguments, a preliminary issue has arisen as to whether the court should revisit the objective limb at all. And the official solicitor, in her written case, at paragraph 60 of supplementary bundle, page 26, suggests that the court should exercise caution before deciding to revisit the objective limb absent a factual matrix. The charities in their written case argue that it would be wholly wrong for the court to do so, at least in this reference, and that's referred to at paragraph 64, hearing bundle 255 to 257. I respectfully agree with the official solicitor that there are reasons to be cautious, given the large number of people who are potentially affected, and the obvious need for and apparent prior lack of legal certainty as to what constitutes a deprivation of liberty, and that's in the charity's written case at hearing bundle page 259. But I recognise that this court already is being asked to clarify the decision in respect of limb B. And so if it doesn't address the objective limb against that background, having been invited to do so, there may be a lack of clarity for the large number of people affected as to whether the decision on that point remains good law. So I say there are legal...
Sorry, just on that. I mean, I thought we had to answer the Attorney General's reference.
Yes.
So why wouldn't we take account of the whole of the law relevant to whether...
I think that's what the Lord Advocate is about to say.
That's what I'm saying. So what I'm about to say is there are legal certainty arguments in favour for revisiting the objective limb, and I consider it's appropriate that this court clarifies whether, and if so in what circumstances, the approach in Cheshire West should continue to be applied. So I think it is appropriate for me to leave...
The approach to limb A.
Yes.
So I think it's appropriate for me to leave the majority of the argument in relation to that, for and against the Secretary of State's position, to those who have already addressed it in writing. Because of the process that the reference is taken, there is no written case that for the Lord Advocate in relation to the points made by the Secretary of State. It's just the outcome of the procedure that we're following.
Lord Advocate, could I just ask for clarification on one point? You prefaced your submission with the words, if the Supreme Court does not address issue B. Is it not...
Issue A.
Limb A.
Limb A.
Limb A.
No, you prefaced the submission with the words, if the Supreme Court does not address B, should we not address it in any event?
I'm sorry, I said B instead of A. I'm talking because to begin...
Understood. Thank you very much.
Yes.
I think what you're saying is we should address limb A because if we leave it, then everyone will assume that what Cheshire West says about limb A still stands, and if we're not happy with that, then we should deal with it.
Yes.
But, I mean, addressing limb A can involve two questions. The first is the acid test too narrow even for an entirely objective test? Or does the Strasbourg court raise a more multifactorial approach, but still just being objectively ascertainable facts? And that's a different approach to saying that wishes and feelings come in not only in limb B as to whether there's consent, but also somehow come in to limb A as part of the question of confinement. Now, that seems to me two different approaches to clarifying what Cheshire West said about limb A, and which is your approach, or are you not plumping for?
So I'm going to come on and address that particular point. And it is an issue that the Secretary of State looks at in her written case, and particularly looks at the question of whether or not it's appropriate to combine all of these factors into limb A. So what the Secretary of State says, I think she supports the position that the objective and subjective conditions overlap, and the Stork approach is a disadvantage that risks artificially separating out relevant facts. I think that's what my lady's driving at, and I can put it shortly at this stage before returning to the argument that I was hoping to get through, is that it makes sense. The case law from the Convention, from the Strasbourg Court, makes sense because it sensibly separates out the subjective and valid consent from the first necessary consideration. That is there a deprivation of liberty? Is there a confinement? So I suggest the separation is essential because consent cannot negate a deprivation if it's not valid. And it would prevent state actors from circumventing safeguards by claiming consent on behalf of vulnerable individuals. So I see that by treating the subjective element separately, the court ensures that individuals who are confined and who are deprived of their liberty receive judicial oversight, access to legal remedies, protection against arbitrary detention. And this approach aligns with the purpose of Article 5 to protect individuals from unjustified or unlawful deprivation of liberty, regardless of the intentions behind the confinement. So the objective assessment is a crucial protection against the arbitrary removal of a person's liberty, particularly for those who lack the capacity to consent. And relying on subjective factors at the stage of the objective assessment, like whether someone is consent and not actively objecting, would, I say, fail to protect individuals who cannot communicate their objections or understand the right to leave, and the fact that a person's compliance may stem from their disability rather than genuine consent. So a separate and distinct objective assessment ensures that a deprivation is properly identified regardless of how commonplace or caring the setting may appear to be. And without this test, there would be a risk of normalising highly restrictive conditions, especially within institutional care. And so a factual inquiry, independent of a person's wishes, feelings, understanding and acceptance, ensures that the court doesn't overlook real-world restrictions simply because, for example, they're framed as a cure or treatment or the right level of support. So I say the objective analysis is crucial to recognise the actual impact on the individual and avoiding the dilution of Article 5 protections. And so at a principled level, using an objective standard, the legal framework adheres to Article 5, which prohibits arbitrary deprivation of liberty, and the test ensures that proper legal procedures like deprivation of liberty safeguards are triggered to protect individual rights. And more fundamentally, the key legal and philosophical rationale is that liberty is a universal right, not contingent on one's ability to exercise. So it's not merely about the ability to make choices, it is about the freedom from arbitrary confinement. Even if a person cannot consciously choose to leave a place, they still have a right not to be confined without legal safeguards. And the cases of HM against Switzerland and Stanov against Bulgaria emphasised that the objective situation, such as continued supervision and lack of freedom to leave, can amount to deprivation of liberty, regardless of a person's awareness or consent. So I see, paradoxically, incapacity strengthens the need for legal protection. It doesn't weaken it. And if someone cannot consent or understand their situation, they are more vulnerable to abuse or neglect. So that's why I say it's very important to be careful about the what seems an attractive argument by the Secretary of State for Health, supported by the writings of well-recognised academics in this field, it's important to think about why the Strasbourg Court has identified the approach that it has done over all of the jurisprudence that we've looked at.
So, I mean, you, in this latest submission, you seem to be saying, is this right, that if a person's in a catatonic state, so they don't even have the minimal level of consciousness that I was putting to you earlier on, they will be subject to a deprivation of liberty if they're in a confined place?
I didn't say that.
No, okay. I misunderstood you then.
And in fact, I think yesterday I was asked about the individual who is in a persistent vegetative state, and I said that individual...
That's a little... Oh, sorry, that's all right. Go on.
Yes, that individual wouldn't be confined because they wouldn't be subject to constraints.
Okay.
But I'm saying that if a person is subject to constraints, but they don't have even the autonomous concept of being able to consent to that, that your concern is that if there's no valid consent, because they don't reach that level of being able to consent, if they are objectively restricted, then the fact that they're not objecting to that, because they don't have that ability, shouldn't mean that they're treated as not being deprived. They are still being deprived of their liberty, because the question is, in Lim A, is the objective point, and it's not overridden by their lack of objection if the reason why they're not objecting is because they are incapable of consent.
That's exactly, and that's why that's following exactly what the court has said in the cases that we've looked at, and that's why they separate out the concrete situation of the individual, which is measured by a whole range of material, type, duration, effects, and manner of implementation of the measure in question, but you do then have to look at the subjective test for valid consent. It's dangerous to mix it all together.
Right, and your concern is that if you merge it all into one, then you just say, well, they don't seem to be objecting, we don't have to look at how restrictive the regime is. Yeah.
And that's what, and it's we're dealing with the most vulnerable members of our society when we're looking at the issue that's before the court today. And and that's why I'm here in the public interest, to ensure where I can that the court understands what the necessary safeguards are and how they might be read from.
I have some difficulty with that. I'm sorry for interrupting. But the Article 5.1, the first question you decide is whether the person is deprived of liberty. Yes. And thereafter, it's got to be in accordance with the procedure prescribed by law. And the precautions that I think you're envisaging is, how do you put in place precautions in relation to assessing whether somebody genuinely consents, whether their wishes and feelings are genuinely being relayed appropriately? And but at the moment I can't see how the procedure prescribed by law comes into effect if the person isn't detained.
Well, it would only come into effect if there was a deprivation of liberty.
Yes, if there's a deprivation of liberty, it depends upon, amongst other factors, whether they consent, whether their wishes and feelings. And that raises, in turn, a very difficult task of whether they do or don't consent.
Yes.
And very difficult in relation to people with autism, for instance, or a whole series of conditions. And,
I don't believe.
But you're suggesting precautions in relation to that assessment.
I am.
Yes.
But I'm only in relation to the care that would need to be taken. There also is going to have to be care taken. Yeah, that's all I'm saying. But what I don't think I said anything differently to what my Lord has said.
Right.
The notion of deprivation of liberty within the meaning of Article 5.1 contains both an objective element of the person's confinement in a particular restricted place, for a non-negligible period of time, and an additional subjective element in that the person hasn't validly consented to the confinement in question. So those are the features. And then if they're confined and have not validly consented, there's a deprivation of liberty, and then you have to make sure that the necessary judicial oversight comes into play to ensure that their deprivation or the detention is not arbitrary. And my point is, you've got to take great care before you start to say, Lim A is all very inconvenient, let's just put it all together and assess the concrete situation of the person on the basis of their wishes and feelings.
And to some extent that's being done in the Cheshire West case by Lady Hale. She discussed Limikailov's case,
Yes,
for
she
example, and the differing views taken of the two placements in that case on the basis of the attitude of the patient. And she's doing that in relation to a discussion which is entirely concerned with Head A. So, if there's a problem here, it's a problem that's in Cheshire West itself. The other point that occurs to me is a lot of this discussion is taking place as though people have to be deprived of their liberty in order for there to be any safeguards. And that's not right.
No, it's not. That's not what's been said either.
Good, good.
I think that in fairness to Baroness Hale, I think she was going through the relevant authorities in Cheshire West and identifying the issues, and then she does bring it all together by identifying what the relevant issues are in the case before the Supreme Court at that stage. And it wasn't valid consent because of the position taken by the parties. And if that's where the judgment is lacking, then I say, rather than overruling it, all you would need would be a clarification. So, in relation to then the point that I was making, that there's no departure from Gazzardi that in Cheshire West, that it is actually applied. The Secretary of State's argument that Gazzardi was departed from, I say, is inconsistent with the fact that the Gazzardi test is cited on multiple occasions. And I refer to a number of these, and in light of the time, I'll give the citations to the court. HB 2938, HL case at paragraph 7. HB 2942, paragraph 20, that's in relation to one of the Stanov general principles. And at page HB 2951, for the point about repetition, that is at paragraph 48. It's expressly applied at paragraph 48, HB 295, insofar as Baroness Hale asks a question in respect of P, MIG and MEG. So what are the particular features of their concrete situation on which we need to focus?
Sorry, which paragraph?
That's HB 2951 and paragraph 48.
48, thank you.
At the very last sentence.
Yeah.
It is correct, I say, that Baroness Hale proceeds to focus on two aspects of that situation, those of which would come on to be described as the acid test, but the Strasbourg jurisprudence does not require or itself insist on the mechanical application of the Gazzardi test. And the court in Cheshire West did not fail to reflect that jurisprudence by identifying certain key features of the concrete situation and applying them to the particular context at hand. By way of simple example, at paragraph 89 of HL against United Kingdom, at page 4625 of the hearing bundle, the court referred only to key factors in the context of the discussion of the concrete situation. and at paragraph 91, HB 4627. This is also how the matter was reflected in how the court ultimately approached the matter in Stanev, HB 4910, at paragraph 124, when they look at the objective aspect, and at paragraph 128 at 4911, note that the applicant was under constant supervision and free to leave. And at paragraph 4911, they identified that the duration of the measure in question was essentially indefinite. And 132, HB 4912, summarises the position, paragraph 132. So what I say matters is the substance of approach, not the form. And the substance here is that it is the question, so what are the particular features of their concrete situation on which we need to focus? And Baroness Hale answers that by way of an acid test proposed at paragraph 49, hearing bundle 2951. I say it was therefore, if we read the case objectively, precisely the concrete situation of P, Mig and Meg, which was being considered by her in asking whether the individuals were, firstly, subject to continuous supervision and control, and secondly, not free to leave. I do say that it's appropriate to recognise that the dicta of Baroness Hale was considered by Lord Carnwath and Lord Hodge in their dissenting judgments to set down what they described as a universal test applicable to all, regardless of any physical or mental disabilities. That's what's said at HB 2962 at paragraph 94, and also HB 2963 at paragraph 98. And there's a reference to the general test proposed by Baroness Hale. I say that the meaning of that dicta and the majority decision, however, when approached objectively, it's easily seen that the universality of the test was directed to the irrelevance or the objective limb of the presence or absence of disability, a point that was agreed by Lord Carnwath and Lord Hodge in principle at paragraph 88 of their judgment.
Sorry, what are you saying?
So I'm saying that when you read the judgment objectively, it wasn't a universal test for everyone that Baroness Hale was dealing with. It is specifically directed to the situations to which the test might be applied, and particularly directed to the cases of this kind, of this type, which the court explains in the opening paragraph of the leading judgment, which is that this is a case that deals with, let's get the words again, the deprivation of liberty safeguards, the criteria, for judging whether the living arrangements made for mentally handicapped persons amount to a deprivation of liberty. So it wasn't a universal test. The court was specifically applying the Strasbourg jurisprudence, the Gazzardi test, identifying the concrete situation that they had to deal with in this case. And that was the test that she was referring to, the universal test.
I think you're conflating two things. Are you saying that the acid test in paragraph 48 is simply an acid test in the case of P, Mig and Meg? Or are you saying it's an acid test for all circumstances where a mentally incapacitated person is subjected to care arrangements? It's the latter, isn't it?
Yes.
Yes.
And it's
and the critique of the dissenters was the idea that one had a universal test in respect of all mentally incapacitated persons.
I think that, if that's the objective reading of the judgment, my position is that it's evident from the fact that Baroness Hale expressly agreed with the approach suggested by the charity interveners, who'd listed indicators of when there is a deprivation of liberty, but who did not suggest that the court should lay down a prescriptive list of criteria, that Cheshire West is in short an acid test for appropriate cases, such as those of P, MIG and MEG.
But if you read 48 and 49 of the majority judgment, where there do we see the what she's saying is that there are certain things which aren't relevant? That comes afterwards in 50.
Well, I see that the order of the judgment, but for my part, if we look at the judgment objectively, the particular test that was being considered by Lady Hale related to this type of case.
Mm-hmm.
So, but are you accepting it would be applicable in any case involving a mentally incapacitated adult who is confined to a degree and in respect of which a decision has to be made as to whether they are deprived of their liberty?
So I think it is a test that you look at in the context of the Strasbourg jurisprudence and the case of Guzzardi, and you identify the concrete situation for those individuals.
No, sorry to. Are you accepting that it is a universal test for that group of cases, and not just a test applicable to P, MIG, and MEG?
And I've said that.
Then you said something that seemed to contradict that. No. But you are accepting it's a universal test for that group of cases.
For that group of cases.
Right.
But why is it restricted to that group of cases? Guzzardi was involved people who were members of the mafia.
Yes.
And that's where the test originates from. Well, why isn't it a universal test in relation to Article 5?
Guzzardi is a universal test.
Yes.
No, the acid test.
Oh, the acid test. Oh, I see.
Yeah,
I do apologise, yes. I see. So the acid test, you say, is restricted to this group of cases.
Yes.
And Guzzardi is universal test, right?
Yes.
Yeah.
So is this what you're saying, that Guzzardi is a universal test, and that's a test you have to look at the concrete situation and take into account the factors? But when you're dealing with a person who lacks the ability to consent, let's call it that rather than blur it with capacity, dealing with a person who lacks the ability to consent, so they are not consenting under Limb B, the concrete factors that you take into account to decide whether they are confined under Limb A are the two factors, the constant supervision and the inability to leave. Is that where you get?
So that's the difference between restrictions on movement, serious enough to fall within the ambit of deprivation of liberty under 5.1, and the mere restriction of liberty are obviously only subject to Article 2 of Protocol 4, but as the question is one of degree or intensity, not one of nature or substance. And in relation to the test in Guzzardi, in order to determine whether someone has been deprived of liberty, the starting point has to be the concrete situation, and account has to be given to a whole range of criteria, such as type, duration, effects, and manner of implementation of the measure in question. And that's the universal Guzzardi test. But when you come to deal with this particular type of case, with these individuals with this type of vulnerability, that is the way in which.
And what's the justification for doing that? Why move away from the Guzzardi test in this particular type of situation? What's the justification for doing that?
The justification is because of the nature of the individuals that we're...
And how does the nature of the individuals impact the test? Rather than looking at all the factors as opposed to just two.
Because it's the identified concrete situation for this individual, which is that they're under constant supervision and control and not free to leave.
But
that's the test.
How do you reconcile that with Stanev at 115, which is 4909? And Stanev was a mental incapacity case, I think. In order to determine whether someone has been deprived of his liberty, The starting point must be his concrete situation, and account must be taken of a whole range of criteria, such as the type, duration, effects, and manner of implementation of the measure in question. How is that consistent with the acid test?
So I think that what we can do is to look at how Baroness Hale actually identified the acid test in this particular type of case, because she did actually look at the features that the Lord and Lord Cornwall looked at when they looked at how the Baroness Hale and the majority were approaching matters. And you set down a number of factors that should be taken into account, including factor D, which was the fact that a regime is no more intrusive or confining than is required for the protection and well-being of the person concerned, the degree of intrusion being relevant to an analysis of the nature of the regime in place for the individual. So I accept it's a relevant part of the analysis when one comes to consider degree and intensity of the restriction, and as part of the consideration of an individual's concrete situation and the process of taking account of a whole range of criteria, such as type, duration, effects, and manner of implementation in question, in determining whether or not they're deprived of their liberty, is indeed set down in Gazzardi at 92 and 91, and the paragraph that my Lord's just pointed to. I do agree that Baroness Hale doesn't explicitly refer to this aspect when she formulates the acid test at paragraphs 48 and 49, but I respectfully suggest that in reading the case objectively, her formulation of the appropriate test in cases of this nature, that of continuous supervision and control and not free to leave, implicitly contains all the necessary elements of the Gazzardi test, because it is legitimate to suggest that the reason that Baroness Hale did not explicitly deal with degree or intensity by using this particular phrase or wording is because at paragraph 48 she recognised that in the case of P, Mig and Meg, these were not cases that were about the distinction between a restriction on freedom of movement and the deprivation of liberty. In other words, she didn't see these as borderline cases. But the degree and intensity of the measures involved in their places were carefully explored. And we see that at paragraph 51, 52, and 53.
Just have a difficulty in following it. Are you suggesting, are you advocating for the acid test in this type of situation?
Yes, I am.
Yeah. And, well, another case is DD against Lithuania, 4846. And paragraph 55 and 57. That was another case in which the person lacked mental capacity, and they applied the objective test.
I think that's Ketsia.
We've looked at DD against Lithuania, and I accept that that's the way in which the case is formulated there.
Yes.
But it is a different set of circumstances.
Right.
We're talking about a particular type of case that involves...
and you say in this type of case, it's a subset of the factors that are in the Gazzardi concrete situation that you look at. But I think what you're being pressed about is what is the justification in these cases for only looking at a subset of the factors that determine whether someone is confined or not?
Because of the nature of this type of case, that it involves people with mental incapacity who are being subject to constraints.
But the point that's being put to you by my Lord Stevens is that Kedziov, DD, Stanev all involved cases of people without, under the domestic law, mental capacity to make these sorts of decisions. So what's the justification for the Supreme Court in Cheshire West to adopt this approach of saying only a subset of factors applies?
Sorry to interrupt. As I understand it, is because these are individuals who for the rest of their life are going to require long-term care packages because of the profound nature of their disabilities. That's what I understand, the rationale for the way in which Baroness approached the matter.
But isn't that the same in Kedziov, for example? He had serious problems and was in a care home. I'm just not understanding the distinction between the situations of the individuals in the Strasbourg cases who were, in legal terms, incapable of making decisions about their care and where they should live, and were confined in an objective sense, looking at all the factors. I don't understand what's different about P, Mig and Meg, or this group of cases in a domestic context that means we should only look at the subset of factors.
Well, that's the way in which the Lady Hale approached the matter.
And you're saying it's right?
Yes, I am. But
So why?
I'm saying it's right because of the profound nature of the disability and the fact that we have a recognised situation where these individuals in the community are going to be exposed to this level of constraint for the rest of their life. But what I say is this.
And how you reconcile it with the fact that by statute we're meant to be the statute requires the approach to be based on the Strasbourg law. The acid test isn't found anywhere in the Strasbourg law. All the cases repeat a multifactorial test. So, if you like, whether it's right or wrong, the acid test isn't a reflection of the Strasbourg approach, which is what the statute requires.
Well, my position is that it distilled essentially for these types of cases the necessary approach. And I say the key factors approach, acid test approach, applies specifically in the context of these types of cases under consideration, long-term care packages. Depending on the circumstances in other types of cases, that approach or test may not provide a complete answer to whether or not a person is deprived of liberty.
I mean, the key point that's been put to you is the acid test approach consistent? Does it agree with the approach that we see in Stanev and DD and so on from the Strasbourg court?
So my position is that it does, because the acid test in these types of cases distilled into key factors the aspect that key factors as to what would have to be looked at in terms of a test for deprivation of liberty. And the key factor approach was what the court did in HL and indeed in Stanev. They looked at the generality of the test and distilled it down to key factors.
Well, I question that on HL. I've just been looking at paragraph 93 in HL, at page 4627. And this is where the Strasbourg court distinguishes the case of HM in Switzerland, because the British government in HL was saying, well, they were compliant, there was a sufficient expression of valid consent, therefore not deprivation, and that submission was not accepted. But at paragraph 93, the Strasbourg court records considerable reliance placed by the government on HM in Switzerland, which was placing an elderly applicant in a foster home to ensure necessary medical care. So that's a long-term care package of the kind that you're talking about. And in that paragraph, they make it clear that the mental attitude of the elderly lady was a factor which is to be taken into account alongside the other basket of factors on the Ghazardi approach. So it's not something completely separate from Ghazardi. It's a factor which, if there is an expression of consent to the situation, may feed into the Ghazardi evaluative assessment whether there's a deprivation at all. That seems to be, if I may say so, directly contrary even to the limited submission that you're making in relation to care package cases.
Well, I have made the submission I have, and in the time that I have 15 minutes left.
All right.
And I'd like to move on to the second argument that relates to the case of Ferreira. This is in the Secretary of State's bundle, page 109.
So what's the page number again, sorry?
109.
Thank you very much indeed.
Supplementary bundle.
No, in the hearing bundle.
Yes.
It's at paragraph 39. And hearing bundle,
109,
page 109, paragraph 39. And the question in the case of Ferreira was whether an individual with Down syndrome who died in an intensive care unit was deprived of her liberty at the time of her death, and so died in state detention for the purposes of the Coroners and Justice Act 2009. The result of the Secretary of State's argument based on Ferreira, if it were to be accepted, is not clearly identified in his written case, but is assumed on the basis of the no discrimination discussion at paragraphs 39 to 42, hearing bundle 109, to be that Cheshire West would no longer apply to a social care setting where the individual has a profound physical or mental disability. So Lady Justice Arden gave the leading judgment in the Court of Appeal, advancing two main reasons for refusing the claimant's appeal under reference to Article 5. The first reason was that there was no deprivation of liberty because the restrictions fell outside Article 5.1, that's at page 89, paragraph 89, and Cheshire West was distinguishable since it's directed to a different situation, namely that of a living arrangement of persons with unsound mind. That's paragraph 91, both at page 3214 of the...
Sorry, what's the page number again, please?
3214.
Thank you.
Thank you very much indeed. Thank you.
So distinguishing Cheshire West, I say the court was right to do so, and I invite this court to endorse the way in which the court approached matters in this particular case. And the second alternative reason given by Lady Justice Arden was that even if Cheshire West applied to the circumstances, there was still no deprivation of liberty as the acid test had not been met, either because, perhaps artificially, the claimant's sister was free to leave, that's at paragraph 96, or more properly, because the not free to leave aspect of the test, at paragraph 98, hearing bundle 3216, she said it was designed to apply only where the second element, lack of freedom to leave, was a consequence of state action, particularly state action consisting of the continuous supervision and control constituting the first element of the test. So as was put more fully at paragraph 99 at page 3216, the court said in the case of a patient in intensive care, the true cause of their not being free to leave is their underlying illness, which was the reason why they were taken into intensive care. The reason may have been rendered unresponsive. They've been rendered unresponsive by reason of treatment they've received, such as sedation. But while that treatment is an immediate cause, it is not the real cause. The real cause is their illness, a matter for which, in the absence of special circumstances, the state is not responsible. It is quite different in the case of living arrangements for a person of unsound mind. If she's been prevented from leaving her placement, it's because of steps taken to prevent her because of her mental disorder. Cheshire West is a long way from this case on its facts, and that, in my judgment, indicates that it's distinguishable from the situation of a patient in intensive care. So the Secretary of State relies on the sentence, the real cause is their illness, as a matter for which, in the absence of special circumstances, the state is not responsible, to argue that, and this is at page 107 through to 109 of the hearing bundle, the logic in Ferreira would apply equally to social care settings if the true cause of the person not being free to leave is their underlying disability. The state is not responsible for that either. So at paragraphs 41 to 42 of Hearing Bundle, page 109, the Secretary of State rejects the suggestion that his conclusion results in liberty, meaning something less for those who, because of their impairments, are unable to enjoy that liberty. And I would invite the Court to reject the Secretary of State's submission that the logic that he extracts from Ferreira applies on the basis that it results in precisely such a discriminatory outcome. And in doing so, I would respectfully endorse the essential point being made by Lady Justice Arden at paragraph 99, which is that in the case of a person with mental disabilities, the focus for Article 5 is not on their disability, but rather, whether, using her example, there have been any steps taken to prevent them leaving. In short, whether there are any facts or measures superimposed on top of any disability which are objectively indicative of the person being confined, whatever the nature of the disability underlying those measures. So I say if there are then, for the purpose of Article 5, it's those facts or measures and not the individual's underlying disability that gives rise to the deprivation of liberty. And such an approach, which was the one adopted in Cheshire West, ensures that the objective limb is applied equally to everyone, that's the opening word of Article 5, so that the question of whether they're confined is answered in the same way for a person with a mental disability or a person without. So I say Ferreira is therefore a principled and correct decision which properly draws out the fundamental requirement for a coercive measure applied in terms of limb C by the state. And the decision is consistent with and doesn't depart from Cheshire West because it does not apply a different standard based on disability in determining whether a deprivation of liberty has occurred.
And do you say the same is true of a person in a catatonic state or with such severe mental health disabilities that they can't form the idea even of leaving, so that even if there were no restrictions on them, they couldn't leave?
Yeah.
You say the same.
Yes.
The same is true.
Yes, I do. Yeah.
It is still a state restriction.
It was not a state restriction. It's the if you take it to the extreme of someone in a persistent vegetative state, you're not constrained.
Well, that's physical. But I'm talking about somebody with mental health issues that mean he or she can't form the idea of leaving. They're confined in a home and prevented from leaving because they're confined, but they couldn't form the idea to leave in any event. Do you say paragraph 99 of Lady Justice Arden's judgment applies to their case, or do you say Cheshire West applies?
I say that you'd have to look at their concrete situation and determine whether or not they are confined. And you would apply the tests in Article 5, and you would determine whether or not they're confined and whether or not there's valid consent and if there's a review.
If they were capable, despite their mental disability, if they were able to leave but were confined, but were unable to understand their deprivation of liberty, that would still be a deprivation.
Yes, and you would need to get valid consent.
They would, but if you go so far as to say that they're unable at all to actually desire to leave under any circumstances, that wouldn't be a deprivation of liberty.
Well, I think you'd need to look at the concrete situation to decide. It's pretty difficult to do to speculate about these types of examples in a vacuum. But if somebody is literally lying flat and can't do anything, they're not constrained. But if somebody, by reason of a mental disability, is in a position that they're not capable of forming any view on anything, then what is their concrete situation? How are they being treated? What's the care package that's in place for them? And you question then whether or not the circumstances fall within a deprivation and whether or not they require review or otherwise. I think it's pretty difficult to move from one extreme to something in the middle without applying the necessary test of, is it a deprivation of liberty?
But why doesn't their concrete situation not include the fact that they're incapable, say because of profound dementia, of forming even a conception of their current environment or a will to leave?
Because so if you're looking at if your question relates to whether or not that issue falls into the objective assessment.
Well, in fact, I wasn't, personally, I think it's a bit of a problem separating out as though they're completely separate elements, the A and the B. I was just asking you more generally. You focused on the emphasis on concrete situation that one sees in the Strasbourg cases. And my question was simply, why isn't it a feature of that person's concrete situation that they're incapable of forming a will to leave?
Well, it may very well be a feature, but what the court has decided in Ferreira was something different, and the principles that the Secretary of State is seeking to draw from it don't apply. It's because we have a different standard based on disability, and I see what the court should do here in light of the Ferreira judgment is to clarify that the objective limb is directed to identify whether there are facts indicative of confinement, and that applies irrespective of an individual's level of disability.
But in Ferreira, wasn't the point that Lady Justice Ogden was making was that, yes, M had background mental health problems, but what she was actually in hospital for was pneumonia and heart problems, and she was being treated exactly like
Anybody
a person of
Anybody
sound
else
mind would have been treated. And what was keeping her in hospital was her physical illness rather than her underlying mental state. But I think what you're saying, although you don't actually agree with this when it's put to you, that if somebody, you can't make the jump from what is said in paragraph 99 in that context. You can't make the jump that the Secretary of State is making, which is the reason why this person is being confined is their mental illness, therefore they're not being confined,
yes.
or therefore it's not a deprivation of liberty.
So
that's going too far.
Yeah, so that's why
There's a borderline between Cheshire West and Ferreira, and the situation of Megan P. may or may not have been, as far as LeMay is concerned, on the Cheshire West side, not on the Ferreira side. But if somebody is in an advanced state of dementia so that they are unable to form a wish to leave, that's probably on the Ferreira side rather than the Cheshire West side.
So I'm just inviting the court to clarify, as I say, the objective limb is directed to identifying whether the facts are indicative of confinement and applies irrespective of the level of disability. So I'm agreeing with you, Lady Rose. So the third argument related to wrongly eliminating lack of objection and coercion, and this was the third argument that the Secretary of State makes, and just for quickness sake, she makes it at paragraph 45, page 111 of the hearing bundle, and paragraph 76 at page 122. And this is on the basis of an expansive notion of a lack of objection. But I see she does so without reference to authority, and but without reference of authority, is inviting the court, in departing from Cheshire West, to confirm that the wishes and feelings of an incapacitated person are relevant to limb A, as opposed to limb B. There is a subsidiary argument that the Secretary of State makes, which I'd also like to address in this section, which is that the acid test says nothing about the presence or absence of coercion. That's at paragraph 43, page 110. And the first aspect of this argument, that Cheshire West is wrong insofar as it concludes that a lack of objection is never relevant, is understood to be based on what Baroness Hale said at paragraph 50, where she refers to the intervention of the National Autistic Society in mind and agrees with the suggested approach which they make. We can see that hearing bundle 2951, and this is where they suggest that a person's compliance or lack of objection is not relevant, the relative normality of the placement, whatever the comparison is made, is not relevant, and the reason or purpose behind a particular placement is also not relevant. For the reasons given above, I agree with that approach. And I suggest that that is correct, and the court should endorse that, because the objective limb is fundamentally concerned with the existence of objective facts indicative of confinement. And that's reflected in what Lord Kerr said in his concurring judgment at paragraph 80, hearing bundle 2959, where he said that the approach adopted by the Strasbourg court to the question of deprivation of liberty is primarily rooted in an objective assessment of the conditions which are said to amount to that state. Also, paragraph 84, 2960, liberty means the state or condition of being free from external constraint. It's primarily an objective state. It's not dependent on one's disposition to exploit one's freedom, nor is it diminished by one's lack of capacity. So I say a person's objection to confinement will undoubtedly be capable of being evidentially relevant in determining, for example, whether they are free to leave, a fact indicative of confinement, as it may only be by virtue of the objection being made that the lack of freedom to leave becomes apparent. And I say Stork provides an example at paragraph 73 at page 4660 of the hearing bundle, insofar as the court has regard in that paragraph to considering the factual situation and whether objectively the applicant was deprived of her liberty, to the fact that the applicant tried to and on one occasion did escape, the subjective limb being considered separately at paragraph 74. So I therefore agree with the Secretary of State case at 110 of the hard bundle, paragraph 44, that a person attempting to leave a particular place or expressing but not able to act on the wish to do so are some of the clearest possible indicators that they're being confined. But that is because they are evidentially indicative of the objective fact of confinement. But I say it doesn't logically follow, however, that the absence of objection or the existence of positive contentment is also relevant, where firstly the inquiry as to the objective confinement and that confinement is able to be evidenced as a matter of objective fact. So the approach of Baroness Hale on this point, the irrelevance for the objective limb of an absence of objection, was, I say, accordingly correct, and the submission of the Secretary of State to the contrary should be rejected, insofar as that submission is based on an expansive notion of a lack of objection, encompassing a positive expression of wishes and feelings, showing that the individual is happy with the arrangements. I say that the court should reject that. That's at paragraph 45, page 111. In addition to the Secretary of State's position...
What does the Strasbourg court mean by tacit consent? And how does that fit in with a lack of objection?
So
Tacit consent is consent unexpressed.
Yeah, I think that's the reference to Milov's case, and I think that the actual exploration of how the court concluded there was tacit acceptance is not clear, and I think that part of the difficulty in the case was the acceptance of the lawyer who was representing the applicant at the hearing that there was an acceptance of the position at that stage, if I understand correctly the judgment and the analysis of Milov's.
What's the difference between tacit acceptance and lack of objection?
Because I suppose in relation to Milov's, he was somebody who was up, walking, capable of instructing a lawyer, capable of objecting. As you can look at tacit questions in terms of contract and the like, it's a different analysis. Yeah. So in addition to being unsupported by authority, I see that the Secretary of State's particular argument is contrary to the principle and the key purpose of Article 5, in that for the cohort of individuals who are the subject of this reference, it would give rise to the same risk of unregulated arbitrary detention which would arise under Limb B without any safeguards being proposed. And I say it's, in short, displacing the issue in this reference from one limb to another, and would moreover deprive the additional subjective element in Limb B of any obvious purpose. And I referred in support of that to Stork at paragraph 74. And at page 112, paragraph 47 of his argument, the Secretary of State develops this issue further to support the position that the objective and subjective conditions overlap, and that the Stork approach is a disadvantage that risks artificially separating out relevant facts. In my submission, the case law sensibly separates out subjective and valid consent from the first necessary consideration. So, moving on then, can I move on to the last part of my argument? Yes, and that relates to the remaining part of the acid test. Okay. But I think before I move on to my last argument, I think I wanted to highlight that to avoid any uncertainty, however, the potential for which is evident by virtue of the Secretary of State's argument, I want to invite the Court to clarify that whether a person objects to their placement, but not their lack of objection, can be evidentially relevant to the factual question of whether they're confined. And finally, in relation to the argument in respect of more extensive measures required in terms of an own home case, I would simply say that that's also not supported by authority, and I rely on the following cases in support of that. The Convention proceeds on the basis of an autonomous interpretation of deprivation of liberty. That's Buzadi at paragraph 103, page 5303 of the bundle. And I say it's because of the autonomous interpretation given to the deprivation of liberty, and no doubt the application of the multifactorial test, that the Strasbourg Court has been able to find deprivation of liberty in a number of different circumstances. Guzzardi, paragraph 95, and also in relation to Guzzardi, I refer to paragraphs 104 to 105, hearing bundle 5303 and 5291. And so I ask...
5303.
5303.
5303.
Thank you.
Paragraphs 104 to 105, and paragraphs 36 to 38, 5291 to 592. The Strasbourg Court also found deprivation of liberty in relation to military regimes it found no deprivation in relation to light arrest, but because of the difference in terms of confinement of off-duty hours to dwellings or military buildings or premises, the servicemen subject to the penalty at that point were more or less determined to be remaining in more or less the ordinary framework of their army life, and that's Engel at paragraph 61. but the decision was not because it was a dwelling, it was because of the nature and intensity of the measure. It may be self-evident that the detention in a Category A prison is a deprivation of liberty, meaning the environment is not irrelevant to the assessment, but that doesn't prevent the same conclusion in relation to confinement at home as these cases show. It's therefore not the place, but rather, as Baroness Hale put it at paragraph 56, it is the constraints that matter. That's Hearing Bundle 2953. Any alternative conclusion would leave potential to undermine the test which the Secretary of State otherwise seeks to apply, which is concerned to the individual's concrete situation, not the particular place that they happen to be confined. And so I asked the Court to endorse the essential premise on which Cheshire West was reached, that the fact that coercive measures might be applied in a home-like environment or a person's own home is no barrier to the finding of a deprivation of liberty in convention terms, and no heightened test applies. So, in conclusion then, my position is this, that in the interest of legal certainty, the Court is invited to revisit the decision in Cheshire West to clarify whether and in what circumstances it should continue to be applied. The Secretary of State's arguments should be rejected, and on the assumption that the Court is proposing to revisit the decision, I'd invite the Court to clarify the following. The key factor...
You're going to have to be very quick.
Yes, so I have just quickly 5 points. The key factors approach to the acid test applies specifically in the context of these types of cases under consideration in Cheshire West, namely long-term care packages. Depending on the circumstances, that approach or test may not provide a complete answer to the question as to whether a person's liberty is deprived. The objective limb is directed to identifying whether there are facts indicative of confinement and applies irrespective of the individual's level of disability. Whether a person objects to their placement, but not their lack of objection, can be evidentially relevant to the question of whether they're confined under the objective limb, and the fact that a deprivation of liberty might take place within a person's own home or a home-like environment is no barrier to a finding of deprivation of liberty, and no heightened threshold applies. So those are my submissions. Thank you.
Thank you very much, Lord Advocate. Ms. Clement.
My ladies, I appear for the Secretary of State for Health and Social Care together with Ms Gannon, and the Secretary of State is grateful for being given the opportunity to intervene in this case. My Lord, the starting point in this reference is the definition section in the Northern Ireland legislation, section 306. That is identical to the definition found in section 64.5 of the English legislation, the Mental Capacity Act 2005. By that definition, Parliament has directed the domestic courts to turn to the Convention to determine what is meant by deprivation of liberty for incapacitated persons. We know that deprivation of liberty is an autonomous Convention concept, and it must therefore mean the same thing across all contracting states. Parliament has decided that it is the case laws of the Strasbourg Court that will determine what is meant by deprivation of liberty in this context. My Lord Sales asked yesterday what would happen if this court is given an authoritative interpretation to deprivation of liberty and Strasbourg subsequently delivers a later judgment. My Lord, we would say this position would then be similar to that arises under Section 2 of the Human Rights Act. And I know my Lord Sales will recall Article 8 in possession proceedings and the repeated House of Lords judgments. The matter would go off again to Strasbourg. It would come back to the domestic courts. So we say the position would be the same as is in Kay and Lambeth. That's 2006 2 AC 465, where Lord Bingham at paragraph 40 to 45 confirms that the doctrine of precedent would still apply, so the Supreme Court's judgment would bind all the lower courts. If there is a new Strasbourg authority, then the lower courts must follow the Supreme Court, but can grant permission to appeal for the matter to work its way through the system. My Lord, we also know that the right to liberty is a fundamental right, and Strasbourg has...
Just on that, when we had this debate with Mr. McGleenan, he accepted that actually there had been no significant new Strasbourg authority since Cheshire West. Do you take a different position?
There is one from the Ukraine that I'll show the court in due course that was in from 2022. We didn't look at that yesterday, but I will take the court to that.
But are you going to be saying that that has changed the law since Cheshire West?
No,
it's not just a question of whether the lower courts are bound. I mean, to a considerable extent, this court is bound by a previous decision unless the 1966 practice statement.
Yes. And, my Lord, we've never shied away from the fact that we say this is in practice statement territory, and we invite the court to apply it.
Yes, all right, thank you.
My Lord, in terms of the extensive safeguards that Strasbourg has laid down, those are safeguards that apply to those who are, in law, deprived of their liberty. Those safeguards do not apply to those who are not deprived of liberty. There may be policy reasons for seeking to extend certain domestic safeguards to all those who are vulnerable and receiving care and support from the state. But those who are vulnerable and not deprived of liberty are protected through a raft of other domestic law safeguards, which we have outlined in the annex to our written case, which is in the Huron Bundle, page 123. So we say it is wrong in print.
You say that the things in the annex apply even if you're not deprived of your liberty?
Yes. My lady, I'll take the court to some of those safeguards in a moment. I'll come back to it if I may. But what we say is that it is wrong in principle to extend the autonomous convention concept of deprivation of liberty beyond the Strasbourg case law in order to fill perceived gaps in the domestic care planning and regulatory regime. So, my Lord, as the court will know, the Secretary of State agrees with the Attorney General for Northern Ireland that domestic law took a wrong turn in Cheshire West, but we essentially advance alternative ways of correcting that wrong turn. The Secretary of State says that the factors relied on by the Attorney General are better considered under Lim A, and that Cheshire West was wrongly decided. As such, we invite the court to invoke the practice statement and depart from Cheshire West. Now, the result of the majority judgment in Cheshire West is that hundreds of thousands of disabled people are now considered to be deprived of liberty in England and Wales, and even more across the UK as a whole. This has been described as the Great Confinement, as in the mass authorisation of deprivation of liberty of a significant proportion of the disabled population. My Lord, this morning we uploaded to the portal a table.
It doesn't result in somebody... It's not because they're deprived of their liberty or because they're authorised that their physical position is going to be the same, whether it counts as legally as a deprivation of liberty or not.
Yes.
I don't think you can say that Cheshire West led to a mass confinement of people. What it led to, maybe, was a recharacterisation of the existing confinement of a lot of people as being a deprivation of liberty.
Well, it led to the existing restrictions being treated as a confinement,
yes,
which made them a deprivation.
Yes, but it didn't lead to more people actually being confined than had previously been confined.
It doesn't change the restrictions that are in place. It means more are treated as being confined as a matter of law.
So to speak of a mass deprivation of liberty is fairly emotive language. I mean, it is merely, as Lady Rose says, a recharacterisation and the imposition of a very considerable burden on the public authorities.
Yes. And the individuals and their families as well, given the intrusive nature of the state involvement that results.
Can I ask,
So what is that? Sorry.
I don't want to be sure if that's right. So far as people who are confined in hospitals and care homes are concerned, I suppose all that is happening is a deprivation of liberty. Or what exactly is happening? And then what happens if you're in a domestic home? I'm wondering if it is quite as simple as being suggested.
Well, my lord, we say it is very, very extensive assessments have to be carried out.
Yep.
I'll show the court the provisions from Schedule A1 in a moment, if I may. But there are 6 detailed assessments that need to be carried out of the individual, the most intrusive of which are the mental health assessment to establish that there is a mental disorder, a mental capacity assessment, and the best interest assessment. Those have to be carried out repeatedly and regularly in order to comply with the procedural safeguards if someone is deprived of liberty. Those are often found to be intrusive by the family members concerned and the individual. They object to being asked repeatedly about their feelings about the state of affairs, about the nature of these intrusions, and the state needing to visit to carry out these assessments. And indeed, there's lots of evidence in the bundle that I'll invite the court to read about the feelings of family members who are very concerned that those that they're caring for, who are living the most fulfilling lives that they can, are being treated as living in a cage, gilded or not. But my lord,
Isn't there some special order, that's a form of order that's had to be introduced in the Court of Protection for people who are living in their own homes?
Yes, so my lord, there's 2 ways. Perhaps we can look at the Mental Capacity Act itself, and I can show your lordship how.
You've got to be careful to distinguish between the exercise of determining whether somebody's got mental capacity, which has to be done regardless of whether they're deprived of their liberty, and the assessments that follow on specifically from them being assessed as being deprived of their liberty.
Yes. My lady, I'll show your ladyship the provisions in Schedule A1 to show the assessments that need to be carried out. And perhaps if I can just say at the outset, I'm going to make submissions under 6 headings. The first was going to be the terms of the Mental Capacity Act and the care planning provisions to deal with the question my lady asked yesterday about safeguards. Second, I'm going to cover why we say it's necessary in order to determine the reference to consider the LIME aspects of Cheshire West. Third, we're going to cover why we say Cheshire West was wrongly decided. Fourth, why we say this is one of the rare cases where the court should invoke the practice statement. Fifth, to respond to the submissions made by the charities and the official solicitor. And sixth, if I have time, to say a few words about our fallback position if the court does decline to depart from Cheshire West on LIME. But if we can turn to the Mental Capacity Act as it applies in England and Wales, this is in the bundle at page 96. I'm sorry, not 96, 709. And section 1 starts at page 711. These are the key principles that apply.
711, did you say?
711, my lady, yes. So these are the principles that apply under the Mental Capacity Act. Presumed to have capacity unless established they lack it. An act done or decision made under this act for or on behalf of a person who lacks capacity must be done or made in his best interests. And before any act is done or decision made, regard must be had to whether the purpose for which it is needed can be achieved in a way that's less restrictive of the person's rights and freedoms of actions. We then have section 2 and section 3, which are determine whether an individual lacks capacity in the first place. We then have section 4, which sets out the best interest test and how one determines what's in a person's best interests. And that involves considering or acting so far as reasonably practicable to permit and encourage the person to participate or to improve his ability to participate in any act done for him and any decision affecting him. And subsection 6, the decision maker must consider, so far as is reasonably ascertainable, the person's past and present wishes and feelings, their beliefs and values, and any other factors. And then also in 4.7, taking into account the views of others about the person's wishes and feelings, etc. We then have the version of Section 4A that is crucial, that's currently in force, is in the supplementary bundle, page 1428. So I'm sorry to ask you to jump around, but it is important we see the right version. And what Section 4A says is that the MCA does not authorise any person to deprive another of his liberty, subject to the following provisions of this section and Section 4B. So the first way in which a person can be deprived of their liberty is if by so doing D is giving effect to a relevant decision of the court. That is then defined in 4A4 as being an order made by the Court of Protection in relation to...
What's the page number again, please?
I'm sorry, my lord, it's the supplementary bundle, page 1428.
Thank you.
So one way of doing it is by way of giving effect to a relevant decision of the court. So the Court of Protection in personal welfare proceedings authorises a deprivation of liberty. And then the second way of doing that is D may deprive P of his liberty if the deprivation is authorised by Schedule A1. That is the schedule that applies to hospital and care home residents. And that is the administrative authorisation process. And then going back to the main bundle at 718, we have the other way in which deprivation of liberty can be authorised, which doesn't arise here at all, but it's about where it's necessary for life-sustaining treatment and essentially to hold the ring while you make an application to the Court of Protection.
Sorry, 718, did you say?
718, yes. Back to the main hearing bundle.
That's Section 4B.
Section 4B, that's right. And I'll come back, if I may, to the role of independent mental capacity advocates. But Schedule A1 is found at 746 of the bundle. And we see what is this about? It's about authorisation to deprive residents of liberty. And we see paragraph 1.2, that the first condition is that P is detained in a hospital or care home for the purpose of being given care or treatment in circumstances which amount to deprivation of the person's liberty. And then it can be done if there is a standard or urgent authorisation in force. We see paragraph 2, the managing authority, so the provider, the hospital or care home, may deprive P of his liberty by detaining him as mentioned in paragraph 1.2. So that's where the authority to do it comes from. We then see at paragraph 12 on page 748 the qualifying requirements. The requirements that have to be met before a person can be deprived of their liberty under this schedule are listed in paragraph 12. These are the 6 requirements: age requirement, mental health requirement, mental capacity requirement, best interest requirement, eligibility requirement, and no refusals requirement. So the age requirement is that the person has to be over the age of 18. So this administrative system of authorisation does not apply to 16 and 17-year-olds. Whereas the Mental Capacity Act does apply to 16 and 17-year-olds.
You mean the Northern Ireland one?
No, the English and Welsh one. The Mental Capacity Act applies to those who are 16 and over.
So they can't use this managing authority authorisation?
That's right. So for a 16 and 17-year-old, they can only be detained either by way of an order from the Court of Protection, or they can also be detained pursuant to an order of the High Court exercising the inherent jurisdiction of the High Court.
So that would be a case like T.
Exactly, my lady, yes. So this part of the schedule then sets out what each of the requirements mean.
But how different are those requirements from what would have been done anyway to determine whether the person has or hasn't got mental capacity under the Section 2 of the MCA?
So Section 2 and 3 are just about determining whether the individual has capacity. So we see the read over to the mental capacity requirement at paragraph 15. There's a specific capacity requirement here. The relevant person meets the mental capacity requirement if he lacks capacity in relation to the question whether or not he should be accommodated in the relevant hostel or care home for the purpose of being given the relevant care or treatment. So that's the overlap. But everything else is an additional requirement intended to reflect the Article 5 requirements when an individual is deprived of liberty. And we see in particular what's additional, the mental health requirement in paragraph 14 and the best interest requirement in paragraph 16. So it's in their best interest to be a detained resident, and in order to prevent harm to the relevant person, it's necessary for him to be a detained resident, and that it's a proportionate response to the harm in question. So again, incorporating the Strasbourg proportionality element.
All this applies to hospitals and care homes?
Yes.
And so what happens I'm sorry for jumping ahead, what order does a parent need to obtain if they have to, if they're in the unfortunate position of having to detain their own child inside their own home?
My Lord will remember T.
Yes.
So if you have a parent who is over the age, if you have a parent of a child over the age of 16,
Yep.
that can either be an order under the made by the Court of Protection under Section 16(2)A, so a personal welfare order, or it can be an order under the inherent jurisdiction of the High Court, depending on the particular circumstances. If the child that is required because of the decision of this court in D, which said that a parent can't consent to confinement of a child who's 16 and 17. There is an open question as to whether a parent can consent to confinement of a child under the age of 16. And there are many cases at the lower level, at least, which say that a parent can consent in that situation. And because consent is provided, there's therefore no deprivation of liberty and no order is needed. I don't pretend that's not a controversial position. There are arguments that a parent cannot consent in that situation, but that has always been the Secretary of State's position, supported by Court of Appeal.
And can Schedule A1 be used for the first detention of somebody?
Yes. My Lord, just to complete this aspect, the assessments that must be carried out are set out at page 753. And these, paragraph 33, these are the 6 assessments that must be carried out by the supervisory body. And then at paragraph 50, the supervisory body is under a duty to give the authorisation if all those assessments are positive.
Paragraph?
Paragraph 50, my Lord, page 756.
Thank you.
And then in terms of safeguards that my lady was asking about yesterday, one of the safeguards is at paragraph 67 of the schedule, page 760, which is the right of a third party to require consideration of whether an authorisation is needed. So it applies if someone thinks there is an unauthorised deprivation of liberty.
Sorry, where are you looking?
Paragraph 67, page 760. So 67.1 defines that 67 rather says there is an unauthorised deprivation of liberty if the person is a detained resident in a hospital or care home and the detention of the person is not authorised. And then an eligible person, 68, an eligible person may request the supervisory body to decide whether or not there is an unauthorised deprivation of liberty.
And who is the supervisory body generally?
That is the body that gives the authorisations. It will be, in England, it is the local authority for the area where the hospital or care home is situated. So we see an eligible person is any 68.5, any person other than the managing authority of the relevant hospital or care home. So it is a friend, a family member, a carer, an advocate, an independent mental capacity advocate. Anyone can go to the supervisory body and say, we think there's an unauthorised deprivation of liberty here. And then various conditions apply about what the supervisory body must do. And 69.2, the supervisory body must select and appoint a person to carry out an assessment of whether or not the relevant person is a detained resident.
And would that be somebody within the local authority?
Yes, it's the separate, it's not the body, it's not the person that makes the commissioning decision, it's a separate team that is responsible for authorising under Schedule A1. And the schedule sets out who they can appoint, who it's got to be, independence, etc., etc. And just to complete this brief section on the Mental Capacity Act, there are also provisions in the Act for IMCAs, these Independent Mental Capacity Act advocates. We see this from section 35 of the Act at page 721.
I'm so sorry, can you give that reference again?
721, my lady, section 35. So this is concerned with the appointment of independent mental capacity advocates, and they must be available to represent and support persons to whom acts or decisions proposed under various sections are being taken. It's dealt with under regulations, which I'll show the court in a moment, but it provides that to carry out the functions, the IMCA may interview in private the person whom he has been instructed to represent and examine various care records.
So for a person without mental capacity who is confined but hasn't been authorised as deprived of their liberty, because the view has been taken by the local authority that they're not deprived of their liberty, an eligible person can challenge that through the supervisory body appointing a person. And would they then have an IMCA appointed?
They'd have an IMCA in the situations that I'm just going to outline now, governed by the Act. So just to complete it, Section 36 sets out the functions of the IMCA, which includes providing support to P so that P may participate as fully as possible in any relevant decision. This is Section 36 over the page. And C, ascertaining what P's wishes and feelings would be likely to be, and the beliefs and values that would likely influence P, ascertaining what alternative courses of action are available in relation to P, and then the circumstances where the IMCAs act are set out from Section 37 onwards. One is the provision of serious medical treatment by an NHS body. Section 38 is the provision of accommodation by an NHS body.
So these are the circumstances in which an IMCA will be appointed?
Yes. And then the one most likely to be relevant if it's the local authority providing the accommodation is Section 39. If the local authority proposed to make arrangements for the provision of residential accommodation for a person who lacks capacity to agree to the arrangements, or for a change in P's accommodation, and are satisfied there's no person, other than those engaged in providing care and treatment for P in a professional capacity, whom it would be appropriate for them to consult. So they're appointed if there's no, say, family member, appropriate family member or friend, etc., who can be consulted.
But it's not the case then that anybody who has been assessed as lacking mental capacity, they don't necessarily have an IMCA appointed as part of that process, or as a result of that process?
No, not always. There's a duty to appoint them in the circumstances I've just shown the court, and there is a power to appoint them to represent P whenever there is a review of the accommodation or care and treatment being provided towards P. And that comes from regulations, the Mental Capacity Act, expansion of role regulations 2006. They may also be appointed in any adult protection cases. So if we're looking at safeguarding issues being raised about P, an IMCA may be appointed in that situation as well. And just for completeness, there are general regulations about IMCAs that set out the nature of their role. That's in the bundle at page, those regulations are in the bundle at page 1085. 1085, my lord. They set out the appropriate experience and training that an IMCA needs. That's at Regulation 5. Regulation 6 sets out the functions of an IMCA, again including interviewing P, consulting anyone involved in P's life, essentially, ascertaining the extent of support provided to P, and importantly, ascertaining what P's wishes and feelings are if P had capacity in relation to the proposed decision. The IMCA must prepare reports. And then Regulation 7 is challenges, so IMCA can make challenges. So where an IMCA has been instructed to represent P, the IMCA has the same rights to challenge the decision as he would have if he were a person other than an IMCA engaged in caring for P or interested in his welfare. So there's the independent person appointed to ascertain what P's wishes and feelings are. So it's not simply the local authority or the care provider saying, we think you're not consenting. There's the IMCA under the Mental Capacity Act who has an important role there. We also see advocates under the Care Act. I'll show the court that in a moment, but there are independent advocates that must be appointed under the Care Act for individuals who also play a similar role to IMCAs in ascertaining an individual's wishes and feelings.
Ms. Client, we're extremely grateful to you for giving us this explanation of the legislation, but I'm also conscious that you've been doing this instead of actually advancing your client's case.
My lord, I'm grateful. In terms of the other safeguards, we have set that out in some detail in the annex, and that covers...
So the Schedule A1, that's not really relevant to us if we're looking at people in their homes, so...
That's right. So
where
Schedule
is
A1. Schedule A1 is care homes and hospitals. Yeah. Deprivation of liberty outside of those settings is in the Court of Protection through either the Section 16 procedure or REX is the streamlined procedure that has been set up post-Cheshire West.
But where is the ability, like in paragraph 67 of Schedule A1, what is the equivalent provision as regards the Court of Protection?
Well, my lady, what one then looks at is the care planning system and where opportunities for representations come in there. We have that through the assessment process, the review process of any care and support plans that are put in place, safeguarding duties, so a local authority's duty to investigate any safeguarding concerns, and positive obligations that arise under Article 5. So where a local authority is aware that there is or may be a deprivation of liberty in a private setting, then the local authority comes under duties to investigate that deprivation of liberty and to, if they can't bring it to an end, to take the matter to court. And we see the discussion of those positive obligations and in a case, Judgment of Lord Justice Mumby in Re A and C, which is in the authorities bundle, page 2721.
Sorry, the page number again, sorry?
2721, my lord.
Those are positive obligations under Article 5?
Under Article 5. But those apply where someone is being deprived of liberty or may be being deprived of liberty. My Lord, we see the holding at holding 2 in the head note 2722, and the full analysis is at paragraph 95, 2757. My Lady, I'm conscious of the time, so I don't have time to go through the Care Act provisions, but I would invite the Court in particular to look at the roles of independent advocates under the Care Act under Section 67 and 68. The references are all there in our annex.
Independent what?
Independent advocates.
27.
Those are the statutory duties. There are then regulations which set out what those advocates are required to do and when they are required to act. Again, it all includes ascertaining the individual's wishes and feelings and communicating those to the local authority. And 2 important statutory guidance provisions. It's Chapter 7 of the Care and Support Statutory Guidance, which is at 2239. And it includes Chapter 10 of the Mental Capacity Act Code of Practice, which includes the role of IMCAs. And my Lady Rose might also be interested in Chapter 9 of the Dole's Code of Practice, which is in the Authorities Bundle at... not the Authorities Bundle, the Curing Bundle at page 1935, headed "What happens if someone thinks a person is being deprived of their liberty without authorisation?" We've also set out in the annex the regulatory regime that will apply and the regulatory requirements on care providers and hospitals to ensure that a service user is not deprived of liberty without lawful authority. So, my Lord, if I could turn then to heading 2 on our list, and why is it necessary to consider arguments about Lim A in this reference? And my Lord, what we say is that ultimately the question for any court is to identify whether an incapacitated person is being deprived of liberty. Stork says that this question has 3 limbs, but the Strasbourg Court has recognised that the factors in Lim A and Lim B will often overlap. And so to take the 2 completely in isolation is, we say, entirely artificial. We also say that the fact that a person is objecting or not objecting to the arrangements is highly relevant to both Lim A and to Lim B. So we accept, of course, that the reference is raising issues as to the meaning of valid consent in Lim B and the particular paragraphs of the code that address this element. But we say it's not possible for the court to answer that question without first identifying what it is that the individual is consenting to. The charities say, well, it's all clear, everyone knows what one's consenting to. It's the residence and care arrangements. But if the residence and care arrangements do not amount to a confinement at all, then there is no need to consider whether the person can provide valid consent to it. So we say it is important that the court is clear about what arrangements amount to a confinement before considering whether and how valid consent can be provided to them. So, my Lord, we agree with the Attorney General that many individuals who are currently treated as being deprived of liberty in law are not in law deprived of liberty and would not be treated by the Strasbourg Court as being so deprived. But we do say that the factors relied on by the attorney in support of her submissions on valid consent, particularly the lack of coercion and the fact that the individual is not objecting to the arrangements, are better considered under Lim A and not Lim B. And my Lord, finally we say that if the court is to develop the domestic law on valid consent, building on the wrong starting point in Cheshire West, this is inevitably going to result in an even greater departure from the Strasbourg case law than we have at the moment, which we say would be contrary to Section 64(5) of the Mental Capacity Act. Now, it is said against me by the charities and the official solicitor that the Secretary of State can just make these submissions in an individual case in the Court of Protection. My Lord, there are two real difficulties with that. First, it's not been possible in the last 12 years to do that. And secondly, the Secretary of State doesn't know when these individual applications are being made to the Court of Protection. There may be rare cases where certain judges will invite the Secretary of State to intervene, where guidance is being given, or they need the Secretary of State's assistance. This is what happened in REX, NRA, the case of Briggs, which I'll show you in due course. And where that occurs, the Secretary of State has taken up that invitation. But in most cases, the first the Secretary of State knows about any hearings on deprivation of liberty is when a first instance judgment is published. If the parties take the matter on appeal, then the Secretary of State can apply to intervene. And again, the Secretary of State has done that. But it's dependent on other parties doing that. The Secretary of State can't write to the court and say, we've seen this judgment, we'd like to be the ones to appeal it. So, my Lord, we've intervened here to make these submissions because, quite frankly, there is nowhere else where these submissions can be made. The government, of course, can't take a matter to Strasbourg to correct what may have gone wrong in Cheshire West. And as a result of Cheshire West, the definition of deprivation of liberty is now so wide and captures so many people that no individual is taking a case to Strasbourg from the UK either. Cheshire West binds all lower courts, so no party is advancing these arguments here. And my Lord, it's also been mentioned about attempts to introduce a statutory definition of deprivation of liberty, but those have all failed, essentially, in light of the Cheshire West judgment. So, my Lord, turning to heading 3, and why we say Cheshire West is wrongly decided. We say that Cheshire West is wrongly decided on the meaning of confinement in the following ways. First, we say the Strasbourg court has never adopted an acid test, either generally or in the context of living arrangements for those who lack capacity. Strasbourg has emphasised from the very first cases on Article 5 that Article 5 is concerned with physical liberty in the classic sense, and that the difference between deprivation and restriction of liberty is one of degree or intensity, and not one of nature and substance. The focus is always on the applicant's specific situation, and Strasbourg emphasises that account must be taken of a whole range of factors in each particular case, including the type, duration, effect, and manner of implementation of the measures in question. Second, the Strasbourg court takes account of the fact that an applicant is objecting to the arrangements under Lim A and requires an element of coercion before concluding that a person is confined. The flip side of that coin is that if an applicant does not object to the arrangements, where a person is capable of so objecting, and the arrangements have a beneficial effect on the applicant, those must also be relevant factors. However, as a result of Cheshire West, coercion is dismissed and the lack of objection is not a relevant factor. Further, as a result of Cheshire West, the court never considers the effect of the measures in question. Third, we say the Strasbourg court pays careful regard to the specific context and circumstances of any restrictions. Yet the acid test takes no account of the type of setting where an individual receives care and treatment, and draws no distinction between the position of an individual in a Category A prison or a high-security psychiatric hospital and as a person supported to live as independently as possible in their own accommodation or in their family home. And fourth, we say that Cheshire West is wrong as it takes no account of the distinction between what we've termed the distinction between liberty and autonomy and the issues we see of Ferreira and those in a persistent vegetative state and those, sadly, at the end of life with dementia. My Lord, I hope just shortly before lunch I can show your Lordship two authorities from Strasbourg on these points. We have outlined the approach taken by the Strasbourg Court and the factors considered by the Court in paragraph 17 of our written case, here in bundle page 98. Not going to turn up all of those cases, you'll be glad to know, but just 2 points from HL and from Stanev. HL and UK is at the bundle 4595.
Again, I'm terribly sorry. What was it?
4595, my Lord.
Thank you. Thank you.
And we see the reference to the end of paragraph 91. We see the reference to what has been termed or continuous supervision and control and not free to leave. And we see that at paragraph 91, which is at page 4636. Now, if that were the acid test, if that were the test adopted by Strasbourg, the analysis would stop there. It doesn't stop there. The Court goes on at paragraph 92 to look at whether the ward was locked or lockable. And at paragraph 93, and this is the point that my Lord Sales put to the Lord Advocate, the Court emphasises in paragraph 93, when distinguishing HM, that each case has to be decided on its own particular range of factors, looking at distinguishing features with HM, and it's looking at the particular factors and intensity of the particular regime that apply in that given case. So the focus is on degree or intensity. The second case is Stanev and Bulgaria at 4884.
Sorry, just on paragraph 93.
Yes.
In looking at degree or intensity, they say that it was taken into account her willingness to enter the nursing home and agreeing to stay. I mean, it's not as though the subjective element is something completely separated off from the general Ghazali basket of factors that are taken into account. It's something that features on this account in that factorial assessment.
Yes, I mean, my Lord, HL predates Stork and the sort of splitting up of the three-limb test, but it is obviously an important factor that is considered by Strasbourg and has been considered throughout.
Yeah. I was referring to Ghazali. I mean, Stork does go back to Ghazali as well. Ghazali has never been departed from as the...
My Lord, every case on Article 5 cites Ghazali.
Yeah. Yes, thank you.
So turning to Stanev and the Grand Chamber decision, we see the Court going through the factual situation of the regime in the particular social care institution between 18 and 32. We see that the most clear indication that Mr. Stanev was objecting is that he'd failed to return to the care home and the police had to search for him and he was collected by care home staff. And we see at paragraphs 102 to 105 at page 4906, the applicant setting out the awful impact on him of the restrictions and the effect of the placement in question. And the Court there refers to the perceptible deterioration in his well-being and the onset of institutionalisation syndrome. Now, we then see at 115, page 4908, the Ghazali test cited again. And yet it's cited again despite this being one of the Lord Advocate's subset of cases of an individual who lacks legal capacity and is living in a social care institution. We then see at 124, 4910, the start of the objective analysis. We see at 127, again the reference to him, Mr. Stanev, not returning, police searching for him. And at the end of 127, it's making clear that the staff returned him to the home without regard for his wishes, again in the objective limb section. Then paragraph 128, we see the reference to be, at 3 lines down, we see the reference to being under constant supervision and not free to leave the home whenever he wished. And again, we say, if that were the only test, if that is an acid test, that is where the court's analysis would stop. But it doesn't stop there. We go on in paragraph 129 to consider the range of other Ghazadi factors. So as regards the duration of the measure, the court observed it was not specified, it was indefinite, he'd lived there for more than 8 years. And importantly, in the last sentence, this period is sufficiently lengthy for him to have felt the full adverse effects of the restriction imposed on him. This is in the discussion of the objective analysis. It's another limb of the Ghazadi test, and it is emphasising the importance of the effects of the measures and the restrictions imposed on the individual.
It's interesting, in 128, they discuss an argument advanced by the government based on an earlier case called Dodoff, that the restrictions imposed on the applicant had been necessary in view of their obligation to protect his life and health.
Yes.
And the court distinguishes Dodoff on the basis that that case concerned somebody with Alzheimer's who required constant attendance. That seems to be treated by the Grand Chamber as a material consideration.
Yes, and my Lord, Dodoff is about the positive obligations under Article 2 and Article 3 of the Convention and the state's obligations to protect life.
Yes, yes. Well, I mean, the point is that the court isn't just saying, well, it isn't just looking at the restrictions, it's also looking at the rationale of the restrictions and possible justification for the restrictions.
Now, my Lord, we don't say that the purpose of the measures is relevant for determining whether there is a deprivation of liberty in the first place. We don't say that. There's lots of Strasbourg authority that say purpose goes to justification if there is a deprivation of liberty, but it doesn't go to whether there is confinement in the first place. What we do say is that the effect of the measures on the individual is clearly being recognised by the Strasbourg court. It's being recognised as part of the objective analysis. And again, we say if the adverse effects of the measures...
Why do you say... Because I thought you said this was before the...
my lady, this is Stanev, which is after.
Oh, right. So, but why do you say this is them looking at what we've been calling Limb A?
Because we start at paragraph 124, where the court says, with regard to the objective aspect...
130 says as to the subjective aspect.
Exactly, my lady. So between 124 and 129 is the objective limb. And then 130 onwards, the court goes on to discuss the subjective element.
I mean, even in paragraph 129, that last sentence that you highlighted, you get a subjective element coming into the first part. The duration is sufficiently long for him to feel the full adverse effects of the restrictions imposed on him.
Well, look, because all of the Ghazadi elements they all go to limb A in confinement. And then Stork adds in the subjective element.
Right, but the point I was making is that it's actually quite difficult to treat the subjective element as completely distinct from all the other Ghazadi factors, some of which will have a subjective effect. And we see here that duration is a Ghazadi factor, and it's being assessed by reference to the subjective effect.
Yes. Well, duration is a factor, but also effect of the measures is one of the Ghazadi elements. So we say it's entirely artificial to say you can look at the adverse effects of the measures on an individual, but not look at the positive effects of the measures on an individual.
But then it is difficult, though, to distinguish between the positive effects and the purpose of the measures.
Well, my lady, it can be difficult, but we do say one is looking at a concrete state of affairs, what has happened to the individual as a result of the restrictions. Now, in Mr. Stanev's case, 8 years locked up in an institution, he's detailed the effects on him. Those are objective elements. One can tell the effects on him. In the same way, we say, if you look at Mig, for example, what were the effects on Mig of the restrictions to which Mig was subjected? Well, she was living with the person she wanted to live with, the foster mother she regarded as her mummy, to whom she was devoted. She was able to have all her care and support needs met. She was able to go to an educational setting daily as she wanted. She went on holiday, etc., with her foster parents. One has to look at the positive effects of the measures, says Strasbourg here in paragraph 129, as part of the Ghazadi test.
I see the time. Can I just go back just for a moment? The discussion of Dodoff in 128 and the final sentence rejecting the government's argument because of an absence of evidence demonstrating the need for protective measures does make me wonder about the irrelevance of purpose. So perhaps you could give us, after lunch, a note or direct us to your case where we'll find a brief note of the authorities that demonstrate that purpose is irrelevant. But in the meantime, we'll adjourn and sit at 2 o'clock.